So let's talk about some legal implications about forensics and some of the important starting court cases that involved forensics. Okay, so we first talk about the CSI effect. Now, a lot of students said, oh, that's like a good thing, right? Like that's like helps get more convictions and it's like helping get the bad guy because we have all these techniques. Actually, CSI effect has had a negative effect on prosecutions and getting suspects conviction rate. So what it really is that because of CSI, because of shows like this, which show a lot of physical evidence being collected and very advanced techniques, the public, especially jurors, has a sort of a inflated expectation of what is possible and have high level of demands for how much evidence is necessary to consider a suspect having enough evidence to say yes, they definitely are the criminal. And so this has been basically reduced to placed a burden on prosecutors that they have sort of a higher level of expectations to meet. So more evidence is needed and more sophisticated evidence analysis is needed. So in general, in terms of prosecutions, the CSI effect has been a negative effect on the forensic industry. So another thing that has been important is this legal case called the Frye Standard. The Frye Standard comes from a precedence of Frye versus the United States. And in this was sort of the original case of deciding what kind of physical evidence, what kind of scientific evidence is admissible in court. And at that point, there became the Frye Standard, which is that in order for evidence and scientific evidence and then findings to be allowed in court, they have to be generally accepted by the scientific community. So it can't be a new cutting edge technique from the Frye Standard's point of view. So it has to be something that is well proven, that has a lot of recognition. So fingerprints by this time have a very long history with a lot of scientific background that's generally accepted that fingerprints are unique to each individual and can be used as a method of identification. However, in the Daubert criteria, in Daubert versus Merrill Dow Pharmaceuticals, it came up that, that's not the only kind of evidence that can be put in. So at this point, they sort of expanded the Frye Standard to including some other kinds of scientific evidence. They said that the Frye Standard is not an absolute prerequisite for admissibility into court. And basically, they left the judge as being a gatekeeper. So the judge gets to decide if it's admissible in court, but the judge has some guidelines they should be looking for. So again, has the scientific technique or theory been tested? And so if it's generally accepted, then that probably is true. Has it been subject to peer review and publication? In other words, is this just one scientist doing this, or have other scientists reviewed this method or this technique or this kind of finding and found it to be credible? So are other scientists who are studying the same area of specialty backing it up? That's what we mean by peer review, that the peers have reviewed it and said, yes, this is credible and believable. The technique has a potential rate of error and they know what the error is, so it can be quantified. So it may not be as low as they would like, but they can at least say there is this much error in this kind of test. Are there calibration? Is there methods to make sure that the method is continuing to operate and that there are standards? So oftentimes that means there's a calibration. For instance, many times in the field, they have different breathalyzers and they need to be calibrated to make sure that they're functioning properly. And if they're not, that can be an issue. So, are there records on maintaining that it's been regularly tested against standards and know that the standards are running at correct levels? And has the scientific theory or method attracted a lot of acceptance in the scientific community? Is it generally accepted? So the final case is the case of Melendez-Diaz versus Massachusetts. And this is a case where that a lot of times we have forensic analysts have to actually appear in court. So in this case, evidence was brought into court and admitted, but they said that due to the confrontation clause, that the defendant has a right to confront their accuser. In this case, their accuser is essentially the scientific evidence, which is the scientist who produced the findings. And so they said that the affidavits or certificates don't allow for cross-examination, so that the analyst themselves often has to appear in court. And this has meant that more recently, forensic analysts actually have to spend up to a quarter of their time in court defending their analyses in a trial. So this falls into Rule 702, which is the part of the code that talks about who qualifies as an expert witness. So generally they appear as an expert witness. And when we talk about expert witnesses, we talk about, so oftentimes it's a forensic scientist. So they're basically serving the job of sharing information that the average individual would not have. So possessing knowledge relevant to the trial that's not expected of an average person. Maybe an average person doesn't understand about fingerprinting or DNA analysis or shards of a headlight analysis. And so they are called to evaluate the evidence based on their specific training, and then they can express an opinion on the significance of the findings. So sometimes the significance involves statistics. In fact, frequently the findings involve statistics. So not only so in a DNA case, it might be saying, that this DNA matches the suspects, but also what is the likelihood that the DNA could match a different person who is not the suspect, and that the suspect might be truly eliminated. So those kinds of things, oftentimes statistics play a very large role. So the forensic analyst ends up needing to be someone who's willing to appear in court and has pretty decent statistics skills in addition to all the other analytical skills.